will. Yeah. We'll just wait for a couple of minutes before we start. Ritwick is signing in again, so we'll just wait for him to join. Okay, maybe I will begin. So welcome to everybody who's already joined. There's been a lot of interest in this webinar, and we have Ritwick as well. So Ritwick, maybe we'll just test that the audio is working. You can hear us?
Yes, I can hear you.
Oh,
Am I audible?
yes, absolutely. Fantastic.
Wonderful.
Just in time as well.
Yes.
So yes, I was just welcoming everybody to this webinar where we're discussing the landmark judgment of the Supreme Court that was given in April of this year. It has been now some time has passed since the judgment, so there have been many articles written about it, some podcasts as well. But I think there is a lot of interest still to understand what this means and the implications of this judgment. So one of the things we've consciously decided in this webinar is that we're not going into the specifics of the judgment vis-a-vis the case of the Great Indian Bustard and sort of the specifics around that, because that is an involved piece as well, and that has a history. So we are not looking into that. There may be some references to that as well. But just to clarify to the people who've joined, we're actually looking at the ramifications of the order beyond that on the issue of climate change and what this means in the larger context. Also, if we were to go into that, we would have definitely wanted to make sure that we have people who have expertise and who have been involved in that case, which we've sort of consciously not done. So we just want to make that clear to everybody who's in the room listening in to us today. I want to thank Kanchi Kohli, Ritwick, Dutta, and Manu Seshadri for joining us. They're all very busy people, all with many, many decades of experience on the issue of both on the legal side as well as on environment. And so we're very glad to have them help us unpack this order. And in terms of the format we'll be using today, each of the speakers will give us sort of their perspective on the order for about 10 minutes. We will have a couple of follow-up questions, and then we will open up to the audience to ask your questions. In the meantime, if you do have a question or a comment, please feel free to type it in the chat box, and the panelists will either respond now or as in the course of what they're trying to say. So first I will go to Kanchi. Kanchi, thank you so much for making time for this. And to those of you who don't know Kanchi, I suppose there are very few of you in this room who don't know her, but Kanchi Kohli is a researcher, an educator, and a communicator on environmental law and policy. She has, again, more than 2 decades of experience in covering the field, in working in this field. And she has also explored through research as well as through work with communities on the ground on the links and gaps between law, development, sustainability, and environmental justice. So over to you, Kanchi, to give your views on this order.
Thank you. Can you all hear me?
Yeah.
Okay. Thank you, Asar, for actually bringing us together on this platform itself. And I think every time something like this happens, it forces us to go back to the document, to actually read commentaries and responses of others. And you actually, because it's coming a little after a couple of months, it's giving us the benefit of all that interpretation as well. And I think it's helping us all locate it within the larger context of within the larger climate discourse itself. So thank you very much, and I'm looking forward to the conversation. I think one of the things these directions have from the Supreme Court actually have landed up doing is probably what it set itself up to, is to almost like rekindle and create a debate about certain subjects, whether it's climate litigation, climate change as a subject. And I think in some senses, some aspects which may have been otherwise technical, or even climate litigation in India, which may have been understood in an incremental way. I think judgments and orders like these land up giving a public face to some of these important subjects. And I think it's so what is a peripheral or incremental thing, other than the impacts that we feel. I think it's opened up that discourse and debate, and so many people want to talk about it. And I think that's an important thing that what the court has landed up doing. And I think what I'll try and do is just from my limited understanding of rereading and contextualizing all this within our own work, is to say how what is the what are the couple of questions or context in that the interpretation of the code leads us to, other than as you're saying, we're not dealing with the Great Indian Bustard context. So for instance, while extending the scope of, say, the Article 21 and Article 14 to and also extending the scope of right to clean environment as already interpreted by the court earlier as right to be free from adverse impacts of climate change. What the court, when you read the text, it at different points of time, it is broadening the scope and narrowing the scope. It's broadening the scope and narrowing the scope. And I think that is important for us to understand because of the vexed subject that we are dealing with. And in fact, when I was trying to even almost prepare for what I'm going to say today, is I thought there may be many different ways we could look at this, but at least 3 ways we could try and understand and locate this judgment within the climate change space itself. The first question is that I'll try and explore and talk about, and I'd love to hear responses and feedback also on it, is that while climate change manifests itself in multiple crises, right? Health, social, ecological, on a whole bunch of factors that even the court has actually interpreted. While that happens, are climate solutions largely focused only on energy transition and emissions? And I think that's an important question for us because energy transitions in their original framing, and I think because the actual operationalization of it through projects, programs, and policies has faced certain kind of roadblocks and pushbacks, etc., was not designed to address multiple crises. And I think it's basically its framing and its entry point has been emissions. And if it's been emissions, then in some senses, you have to realize that this kind of interpretations from the court, the highest court, actually puts us straight into the context that none of these climate solutions are operating in empty spaces. They're going to be all these. So while you're upstreaming, we're lifting the climate discourse to say that it affects all this. But actually speaking on ground, it's a very limited sort of intervention that is happening. So I think in my first thought, I think is something is in this, and I think this is something the climate discourse has been trying to deal with, for a while. Which leads me actually to the second point. And the second point is that if this is something that we're conscious about, then in its broadening and narrowing that the text is trying to do, it's almost like is the pathway of freedom from adverse impacts of climate change limited to renewable energy? By foregrounding the renewable energy as the panacea, although I'm not saying that it's happening, but it tends to give that sort of primacy to renewable energy, in particular solar based renewable energy. And within that, if you further dig down to say the kind of geographies and the kind of scale that you're talking about, while developing a sort of urgency in this whole thing, Rajasthan, Gujarat, large landscapes, it's important for all that. Anybody who understands the climate discourse and also the renewable energy discourse, you would very clearly understand that a certain kind of renewable energy, a certain kind of solar expansion is being envisaged as part of what the court is looking at. Now, what we already know is that such kind of a renewable energy expansion is already problematized. So, while what we are trying to do is the primacy that the court is giving to renewable energy as a solution, and it is idealized it almost like this is the way it needs to be done. You almost get the sense that everything else then will need to be accommodated, even though, as I'm saying, the framing is much more broader. But then it is through renewable energy. So everything else, then the politics of trade-off and prioritization that will come into place. So that's the second point. And the third is something that I think in some senses has always been part of environmental litigation. It's always been part of the environmental justice discourses. If you just bring it up, upstream it or upscale it or downscale it rather to the climate discourse, is the journey between climate jurisprudence to climate justice. And I think judgments can broaden the intersections in their interpretation of a theme or a topic, etc. So, for instance, all judgments or orders, and here it's talking about climate change as a human rights issue, as a food security issue, as a health issue, and it's broad-based, it's being internationally broad-based, but when you're trying to locate it within the domestic context, it lands up being limited to the existing commitments through which governments have envisaged and understood these subjects. So the INDCs, the kind of commitments for net zero, etc., which are largely technical in nature, and again, focused on energy. Now, if that is the case, then the scope of aspects like aspects like energy access, social equity, economic parity, these are the big lifts that courts are trying to take us towards. They get narrowed by what is already there. And I think this is an important opportunity for us to figure out that, as I said, this is an entry point into the story, and nobody was, and what it's done is opened up that debate, to do that. So it's an important opportunity to see the limits of this, the struggles of what the court is trying to put out, the complexities of it, and actually carve out that path of climate jurisprudence to climate justice, and come close to what the court itself understands as a crisis of a monumental nature, of diverse manifestations. So I think I'll end it at that, and look forward to hearing my co-panelists and the feedback and the response.
I think maybe just one question before we hand over to the other panelists, because I mean, I think you put it really well that it constantly broadens and narrows the scope of the discussion, and in some ways, you almost feel the struggle that possibly was being, because it's such a complex problem, that in some ways, in articulating the complexity of the problem, the scope is broadened. But when one speaks about the solution, then it comes down to what is currently in the policy space or currently being discussed as a more technocratic solution to the issue. But I did want to ask your thoughts on, because it does very clearly bring in the issue of equality and of climate justice, therefore. And there it also refers to, for example, even the heat wave that currently is being experienced across the country is affecting the poor in very many different ways than it is affecting people who are able to afford thermal comfort, and people who have to work in the open. So in some ways it recognizes the need for climate justice, but as you say, maybe it narrows the view when it comes to actually articulating how climate justice will be addressed.
Yeah, so I think processes like this are constrained by what is before the court in any case, in a particular case, and it is also probably constrained by how much it can can stretch itself. But I think the fundamental thing for us to go back to, and I think this is not something that we can overnight change, is many of these concerns are actually still addendums to the climate discourse. They are to be fitted later. The primacy is about the emissions focused. And I'm not saying that's not important. I'm really not saying it's important. But so in the design of the technology, what is it, operationalization of the technology or any other processes or policies, these are not the fundamental things. And it makes it even more complicated when you say, oh my God, it's right, this should have happened yesterday, the urgency argument. But the thing is, as many of us know, and almost everybody who's probably here, is this, the verdict is out there that none of this is happening in empty spaces. So when the climate solutions were designed, some of these things were not even, it was like, okay, this is a good project. This is a good idea. Now, how can this good idea create bads? It's almost like that is happening. So the legitimacy question for renewable energy is huge. And that's why I think already people are talking about responsible energy, etc. So I think it's not like nobody can not acknowledge these. The thing is, where is the space for stretching it? And that has to be either through the questions that are raised in the court, or the manner in which planning is done, or how laws are defined, or just sort of a public sentiment about it. I think that's the journey that I was talking about in the end. I don't know if I made sense, but yeah.
Yeah, I think you did. And I think that's a good point to segue into what Manu Seshadri is going to speak about. And before I hand over to Manu, I'd like to introduce him. Manu Seshadri is a founding partner at the MSA Partners. He's also an experienced lawyer on commercial and infrastructure law. He has over 21 years of experience in this field. He's worked on arbitration and commercial litigation, but he's also very much an environmental enthusiast at heart, and he is also looking at addressing these issues. And I think the lines between these are anyway blurring in the world that we are speaking about. So we're very glad to have Manu, and Manu Seshadri, over to you to speak about how you see this in terms of opening up a much more sort of important conversation on a new framework that's probably required to address climate change and climate action.
Thanks, Vinuta. Thank you, Asar. Climate change is the issue of the age. There's no doubt about that. It impacts every aspect of our lives, our work, how we trade, how we travel. It has an impact on everything. So therefore, I'm glad that the Supreme Court has recognized this in explicit terms. But I am going to actually focus on two aspects. One is the court has held that despite recognizing the adverse effects of climate change, there is no single or umbrella legislation relating to climate change and its attendant concerns. Secondly, the court has held that the people have a right against the adverse effects of climate change, and that a right to the clean environment and right against the adverse effects are two sides of the same coin, and it can be it has recognized it as a distinct right under Article 14 and 21. So therefore, what are the tools that we have to deal with climate change? Today we have the National Action Plan on Climate Change. Under that, there are 8 core missions which deal with climate change. One is a solar mission, one is a mission for a green India, one is a mission for a sustainable habitat, water, sustaining Himalayan ecosystems, etc., etc. Now, these missions are all policy statements at the end of the day. There is no law. Moreover, these missions do not enunciate or provide a clear roadmap for our 2030 goals or for our net zero goals, which is envisaged to be reached by 2070. They're all statements of intention. Recently, a carbon credit trading scheme has come about. I understand it has been given effect with respect to steel and aluminum sectors. Also, there is the green credit rules which have come about. But both at their core are offsetting mechanisms. They do not provide a pathway by which you're going to reach net zero. They have high aims, which is to do away with carbon consumption. But at their core, at their heart, they're just offsetting mechanisms. So therefore, as the court has recognized, we need a framework law for climate change. And why? Because it's not enough to articulate a vision. We need to put that policy, convert that into a law in order that we can make a transition to zero carbon. We need to deal with mitigation, adaptation, emissions as well. Emissions can be in 2 forms. We can either come up with a carbon tax, ultimately, as the EU has come up with. We may ultimately have to come up with our own carbon tax. Or we may have a carbon trading scheme and an emissions reduction mechanism. We will probably have to have both. What is important is that we need to bind ourselves to this progress. And this is the only way we can go ahead and achieve our goals of 2070. That is net zero by 2070. So apart from this, there is one other issue. Many of the aspects, many of the interventions to do with climate change are in the domain of state governments, and some critical areas like electricity distribution, urban transport, agriculture, building regulations, among other things. So unless there is a mechanism under the auspices of a law by which there is a high-level committee or a nodal committee which can ensure that the state's goals are in alignment with the national goals, it would be very difficult to achieve these targets. Why law? It would be easier to enforce. It is not just a policy, malleable. You can kick the can down the road, and you can keep saying, making policies which are statements of intention, but unless you bind yourself to a law, you will not be able to progress. Other countries have come up with a framework law. I don't see why we should not. And this is my fundamental takeaway from this judgment. It recognizes the need for such a law in paragraph 19. And I think our legislators, policymakers should be looking at this. Thanks.
Thanks so much, Manu. I think you've sort of laid out the gaps between what we have on hand when it comes to policy and the fact that if we are indeed looking at addressing the complexity of the problem, the existing policies are nowhere near addressing what's required. And without something that is enforceable, we are also again left with intent or targets and
Yes.
no real way of actually enforcing an intent. So thanks for laying that out. One question I had, given your expertise, was also to understand how people who are working on infrastructure, on building new infrastructure in the country, and India is still a country that is growing, that is building a lot of new infrastructure. How is climate being seen as one of the defining sort of lenses through which we will see new infrastructure development? If you have any insights on that.
That's a good question. This is an important recognition. This judgment is an important recognition. And it will be that overarching recognition in very many commercial transactions. Nowadays, people are talking about scope 3 clauses being put into distribution contracts, circularity clauses, other clauses which are ensuring that that there is an aspect of sustainability even in pure commercial transactions. So yes, it will have an impact, and all these developments today could be in a sense related to this judgment. So it's an important recognition. It gives legitimacy to what people are doing on the ground otherwise. And yes, so yeah.
Thanks, Manu. And now I'll go to the sort of the meat of the discussion, Ritwick, in terms of the order itself, which where I think it was very useful to have Kanchi and Manu sort of lay out the broader sort of context but going into the order itself, Ritwick, if you can, and before, of course, let me introduce you again. You need no introduction, but I would like to introduce you formally. Ritwick Dutta is comes with decades of experience as an environmental lawyer. He is also established an organization, Life, and also worked on multiple laws. Worked on getting multiple orders that have had really significant impact for communities. And of course, the recipient of many, many prestigious awards. But yes, Ritwick, now over to you to discuss what the order itself has for us in terms of an opportunity to deal with climate in India.
Thank you, Vinuta, and for inviting me, and to Asar for taking the initiative to have this discussion on this important topic. Having heard both Kanchi and Manu, right, on this important aspect, what I would like to cover is essentially, as you rightly said, is the judgment itself. It's an interesting one. It has the imprint, obviously, or the style of Justice Chandrachud, who introduced this whole concept of writing judgments through index method. So you have the preface, you have the various issues neatly laid out like a book. Now, that was not there earlier. It actually started with his judgment on a Hanuman Lakshman Aroskar case, which is a landmark case in terms of the environmental impact assessment. And you find that him dealing with the entire judgment in different sub-chapters, sections and all. So it makes for a very interesting reading. Having said that, I think we must make a distinction that which is the binding part, which is the obiter dicta part. And if you see, a large part of the judgment is actually stating what the government in its affidavit has submitted before the court. So therefore, it is not really the court stating what it feels. It is only stating what the government has submitted. And what is also very important in the submission is the fact that this is a case where the Ministry of Power, the Ministry of Environment and the Ministry of Renewable Energy, New and Renewable Energy, jointly filed the application and affidavit before the court. So it's rare that three ministries, one wants to use fossil fuel, one wants to move away from fossil fuel, and the other one technically or legally should be the one to enforce environmental standards. But they were on the same page in this case, stating that, so far as the issue is concerned, it need not be only looked from the lens of the GIB, the Great Indian Bustard, but must be looked at from India's commitment to the climate agreement. Now, what is very interesting again, which was highlighted by Manu, is the fact that, really speaking, despite our commitment to climate agreements, it has still not become legally enforceable. Article 253 of the Constitution specifically states that, if you have taken part in any conference, meetings, and agreements, it has to be part of the domestic law. So till today, despite all the talk about climate change, it still remains a policy measure. The very same National Green Tribunal had very clearly held, right, in this matter concerning climate change, that all the action plans are a matter of policy and cannot be legally enforced. So when you look at it, it's a very interesting aspect highlighted, and that the court did not say it, but if you interpret it, the National Clean Air Action Plan is enforceable under the provision of the Air Act. But the Climate Action Plan are not enforceable, despite the fact that the climate agreement arises out of India's international obligation, because India is a treaty, but it does not relate to a domestic legislation at all. It doesn't lead to a legislation. So this is one aspect that the court has highlighted, that, we must actually look at it from an angle as to why there is a gap so far as law is concerned. Now, whether you need a legislation or not is an aspect that can still be debated, discussed and all. But this is an issue that the court has said. The second very important aspect in the judgment itself is that the entire environmental jurisprudence has been based, or the foundation has been always in Article 21, the right to life, right? Well, here they actually expanded to Article 14, right? 14 is important because of the fact that 14 is not just about equality, 14 is also about arbitrary action, arbitrary state action. So therefore, the very fact that climate change affects people unequally, right? So it is not just about the issue of people being free from the adverse effect of climate change. It is also about women being adversely impacted more than men, right? People who are poor are getting more affected. So it takes into account the fact that climate change, unfortunately, is the reality. But at the same time, the law is required to recognize that people are unequally placed when it comes to mitigation and dealing with climate change itself. So when you talk about heat, well, I can sit in my air-conditioned room and have the webinar. That's not usually available to others who are there, who are unequally placed. So that is, I think, a very, very important aspect of the broadening of Article 14 as opposed to only Article 21, which has been the bedrock of environmental jurisprudence there. The next, I think, is a very important aspect. And this is I would say, the test of the case itself, that the court goes into what they say as balancing environment versus biodiversity here, where in Talun Bharat Sangh case way back in the 90s, the Supreme Court said very clearly, the job of the court is not to balance. Balancing has been done by Parliament. The court's duty is only to say whether the law has been followed or not. Now, if you look here, in terms of the basic balancing, the court said, well, the main problem today, based on the Government of India, Ministry of Power, Environment and Renewable Energy, that we need to move away from coal. Now, which is fine. And that is in align with our climate agreement. And if we do not move away from coal, we'll be violating our commitment under the Paris Agreement and all the subsequent agreements. Now, whether the government is able to stand and take the very same stand when it comes to a coal-fired power plant is the real test of this judgment. Because I really doubt, let me say it, and I'll be happy to, if my doubts are proved wrong, that it is unlikely that they'll take the same view. Because if they take the view of Paris Agreement being binding, and which it is, and the fact that India's energy policy will have to be based on India's international commitment, then this judgment has a great importance, because then it can bind. And this will have an impact not only in the Supreme Court, but also high courts and NGTs and government decisions, because the law set by Parliament, by the Supreme Court, is binding on all tribunals, courts, and authorities. So that's an important part. In just about 3-4 minutes, let me just summarize a few more important points here. So the real test is that, well, it moves away from treating coal as the holy cow to something which is a dirty fuel. And that, I think, is the first judicial recognition of coal being problematic. The next one is where the whole issue of climate litigation comes in. Now, if you look at the judgment, well, it's like it's the chapter, the section on climate litigation is a little bit odd in this entire one, because this was not a litigation fought for climate. It was to save an endangered species. But the court highlights climate litigation. It highlights few of the judicial decisions that have taken place in other countries on climate change, and says, well, the court should be ready, to accept more such cases which are going to come in. Now, the question that again arises is, will this judgment be a safeguard against the government which regards climate litigation as actually something no less than a criminal activity, right? So you have a criminalization of litigation, and at least, 2 people in this room are from organizations which have suffered because of, remotely or directly involved in litigation, or supporting litigation, or involved in influencing paralegal processes related to environment and climate. So therefore, the test is, does it recognize and will it be a precedence to safeguard litigants who are coming to the court itself? And my final point will be on the fact that, is the fact that at the end of it, right, will this lead to fundamental changes in the way in which litigations on environment is viewed? Because they have mentioned about Andamans. They've mentioned about the fact that tribals are more affected. So again, will it have impact beyond this particular litigation, beyond this case? And just 2 basic points on which I want to end. First, I think we must be a little careful while reading every single line of a judgment, because one basic principle of interpretation is that a judgment should not be read as a legislation. Right. So it is not that every single line has to be read as if it will guide the way in which renewable energy development is going to happen in the country. And I hope, I'm reminded one of Nariman, who was firstly in his book, Before Memory Fades, had said, do not believe too much in judges or what they write in judgments. They usually don't mean what they write. So I hope that, this is proved wrong so far as this judgment is concerned. And one hopeful sign was, just within a week of this judgment, you had another judgment from Telangana, pronounced by Justice Sundaresh, which actually looked at the economic loss. And I think this is very, very important. The economic loss that is happening because of climate change. And they quoted the RBI report to say that, the entire GDP growth of 8% loss to 7 to 8% will be accounted for purely because of climate change induced impacts and because of environmental degradation. So I think that's a very important aspect to consider, since we are going to be a fully developed nation by 2047. So if RBI says 7% rate of growth is going to be affected by climate change, well, I think that's a wake-up call. Thank you.
Yeah, indeed. No, thank you so much, Ritwick, for laying out the intricacies of the order itself, and helping us understand how to look at the order and how to interpret it. So I had a question, and I think I'm sort of raising something that people have asked in the question below, which is that does this now open the gates for people to actually approach the courts in the absence of any policy? For example, if, let's say, people are displaced by sea level rise, does this case actually open that space for them to, go to the courts in the absence of any real mechanism to deal with it? So does this open the gates for actually addressing other crises other than the GHG emission aspect of addressing climate?
Very good. I think that's a very important point. I think it does open it up. Because if you look at it, when because we must recognize that we don't have a statutory law with regard to climate change. So what we have now is a constitutional interpretation by the Supreme Court, where you go before a High Court or the NGT, wherever is the forum, and we'll say, well, there is a violation of a fundamental right, because Article 14 is a right, Article 21 is a right, and the fact that the courts have linked up the issue of climate change with human rights is a very critical link. Because if you look at the normal discourse, it's been so technological focused. It's about 2 degrees, 1.5 degrees. It doesn't involve the rights angle at all. So when you take up the Article 14 angle, it's something which becomes in a way justiciable, and you take it to a court. Yes, I can't say about what's the success, because success rate all depends on the nature of pleading, the judges who are there, whatever that is there. But it is bound to have an impact. Now, let me just give a very small, short example of this limit one. Say, for example, there is a report of the state of Maharashtra, climate change report prepared by Terry, right, with the government of Maharashtra. Now, in that report, there's a very clear finding that in Pune, there'll be about 37% increase in rainfall by 2030. And now there's an entire project of riverfront development happening. Now, whether they've actually accounted for 37% increase in rainfall and the resultant flood in the decision-making is something which becomes a right on which one can approach the tribunal, which people have already approached it. But I'm just giving an example. So you have all these studies, all these aspects which bring out this entire aspect of the rights which can be actually litigated and fought for in the courts. So therefore, it opens it up, because before that, I always say climate change was an obiter dicta. It was just an observation of the court. There was no authoritative finding or binding finding, which has like Article 141, which is binding on all authorities.
Yeah, thanks so much, Ritwick, on that. And I think, as you say, the question really becomes when the same sort of parameters are also held against infrastructure that is, say, a new coal plant that is being built. So absolutely, thanks for outlining that. And I just wanted to also just add to the audience who are present here, please, we are unlikely to be giving solutions to climate change. So we're unlikely to be talking about the pathways to addressing all of climate problems. So that's not the focus of this conversation. I wanted to go back to you, Kanchi. I think there's a question to you, which is around implementation, the challenge between regulation and implementation. And I think it's open to the others also to come in. But the question, I think, is the challenge always seems to be, even where we have good laws, the challenge always becomes the implementation of that law. And does this in any way signal, at least possibly to courts, when there is a challenge on even existing legislation, that actually, for example, these laws should be maintained? For example, even on air quality, will this, for example, ensure that certain existing legislation on or regulation that exists on pollution is better implemented?
So I mean, honestly, I think all the experience and cautions with both the design of existing regulation, I'll emphasize the design, as well as the operationalization of environmental legislation, should be actually come to play when we are discussing any of these subjects, because we have situations where environmental regulations have also exacerbated other problems. and in our search for the perfect judgment and the perfect regulation to address a singular problem, I think it does run the risk of run the risk of actually impacting one thing or the other. Now, having said that, that's not to say legislation is not important. And I think that's why the framing of a problem in the widest possible sense, whether from the courts or from the government, is very crucial. Because then you can hold the operationalization of any regulation, including environment regulation. So, like if an environmental law or a forest law is actually landing up displacing a poor basti, it is a problem, right? So, in the name of climate change or in the name of anything else. So while so there are two levels, right? I mean, there it is law and its enforcement is the oldest problem. And I think lawyers in the room will know that. Otherwise, nobody will go to court, or nobody will write to governments, etc., or nobody will be out on the streets protesting. So that is the oldest truth. And the other is, if we are talking about bringing new jurisprudence, if we are talking about bringing new legislation, let's be cognizant of the fact that there are limits to this, what you can do. And hence you have, I think I know it might sound idealistic or whatever. If governments and democracy can actually create spaces where problems can be addressed closest to the point of the conflict, where things are, there can be deliberation, there can be consensus to the extent possible, or even trade-offs can be developed in a certain way. You may not need some of these, high-level sort of policing of places or people.
Yeah, thanks. Thanks, Kanchi. I think there's another question that's also coming up, which is linked to the connection. I mean, see, so there is also a challenge between connecting an extreme event and saying this was caused by climate change, which one has seen even with pollution, to say that a particular, say, factory caused a certain health impact. That the challenge of attribution has always been a difficult one to make. And I guess, whether the particular heat wave is a result of climate change, or a particular flood is a result of climate change, or other problems, becomes, I think, possibly something else as well that, is a challenge. So I was wondering whether, any of you wanted to add anything on this question of attribution, which is a challenge irrespective. It's not just a problem with respect to climate change. So that was one question, and maybe the other, I'll just put it out there so all three of you can also speak to it, which is around this thing of, do we need a new framework to actually think about climate action? Because it is complex, and like all of you pointed out, the aspect, it goes much beyond greenhouse gas emission reduction. It needs to deal with many other issues as well. And therefore, shouldn't this open up the conversation on a much broader framework for climate in the country? Yeah.
Yes, absolutely. But just going back 2 steps to what Kanchi had originally, one of the points she'd originally made was that this entire judgment was in the context of energy transitions. It seemed to be focused on solar power. So one point that's fairly critical in this whole conversation is that if we are not going to reach our net zero goals unless we electrify all our sectors, unless we green our electricity generation, whether with wind, solar, offshore wind, whatever. So electricity is at the core of the transition. But the larger point here is it's not just about the energy transition. It's about mitigation. It's about adaptation. It's about attribution as well. So yes, we do need a framework around which we can deal with these aspects separately. We need policies can form part of a framework law as they do under other laws, because you can't have a law around a new technology. You can have a policy around a new technology, like say hydrogen, but it can't be in the form of a law. So yes, you need both working together. We don't have that right now. And attribution, adaptation, these have to be dealt with. I mean, you're talking about people in Lakshadweep who would be, submerged, or people who would suffer on account of climate and would be migrating. How do you deal with those issues? Therefore, Article 14, Article 21. So you need to have a mechanism. You have to foresee what is going on. Other countries are doing it. They are putting in place plans to deal with what's going to happen. We are just still speaking about it. And frankly, something to sort of take off from where Ritwick was coming from. The government should, or our parliament should be framing laws around these things. When a court steps in and says these things, it's not the same thing. This should be dealt with by experts. It should be put up before parliament. A law should be framed around these things. There should be committees to deal with these things, to deal with what the state response is, what the central response is. So there are many steps which have to be taken. And when a court steps in and recognizes it, it's perhaps not the best way to go about it. So that's
quick. And
Yeah.
then Kanchi.
So, yeah, I tend to agree with what Manu has said, and that's important because somewhere, if you look at it, the lack of either a substantive law or a procedural law, because you need both, right, makes everything discretionary, right? So if I today decide that I want to move the court against the danger that's posed because of glacial lake outburst floods, well, I actually can't find a single legislation that actually protects me, right? So, but on the other hand, if I find that there is a water pollution from the smallest of units, or even a service station of a car, I can actually go to the court and get an injunction order against it. But today I can't do, despite all the studies, because it still remains discretionary. Even after the Supreme Court order, right, in this matter, it is still not justiciable on the ground that if I prove a violation, I can go to the court. And that I think is very, very problematic. So if I have to say, well, mangroves are saving me from the adverse impact of climate change because it reduces the impact of climate, well, I don't have any case, right? I'll be in the discretionary jurisdiction under 226 of the High Court or 32 of the Supreme Court. But on the other hand, if I say, well, mangrove is CRZ1 and therefore protected under the coastal regulation zone, and therefore destruction is not permissible under both CRZ and the Forest Conservation Act, well, I have the right to be heard. So therefore, somewhere down the line, this disconnect between our international commitment and our domestic action is something that has to be dealt with. Otherwise, we'll always be at the mercy of judiciary, because the government itself will never really act based only on the strength of a Supreme Court order.
In fact, just to add to what Ritwick said, if you look at our nationally determined contributions, the Supreme Court judgment has captured it as of, I think, 2015. And if you look at the NDC as of August 22, it's substantially the same. The needle has moved very little. So, and in fact, we have not filed any adaptation plan either, which I think we are mandated to do under the Paris Agreement. There was some Cancun framework where we had agreed to file adaptation plans. Many other countries have, which we're yet to do. So.
Yeah. So, yeah, over to you, Kanchi, for your closing thoughts, and then, in case there's somebody else with something else they really want to add, we'll do that, and then close it for today's discussion, at least. There's definitely a lot to continue to dig into.
So, I mean, I don't want to contest anything that my co-panelists have said, but I think I'm far less, I think, inspired by new laws and new frameworks for that. But I think that's not to say. So let me just reframe this. Basically, I think, idealistic as it may sound, I think we need a recognition at the highest level, whether it's the constitution or at the government, etc., that climate change is a crisis which has many faces and it's got many facets. It's not a very singular energy-centric sort of crisis, where its manifestations are very much, you can design solutions like that. Any interpretation or any law that is designed after that will need to flow from that sort of recognition. Otherwise, we are going to only have very legal frameworks that will address specific aspects or in silos. Having said that, I know strategically and even to get remedies and solutions, those are important, and those have been important, having an air pollution law, etc., etc., etc. All those things are there, and some of us have studied it, worked on action research projects about it. So it's very important for relief, for remedy, etc. But if you're framing, it has to be a recognition that it's a multifaceted crisis. So nothing that flows from that should ideally at least recognize that you're framing something that is addressing at least 50% of that multifaceted crisis. Otherwise, you will be again operating in silos. Environment and communities will be at loggerheads, all those kinds of things. Corporates and communities might be at loggerheads. So I think some of those things may be important. And that's not to say for relief, some of these things are not necessary. They're definitely necessary. But I would like to lift it much more at the hands of much more as more ethics and commitment, and everything else flows from it.
Yeah, thanks so much, Kanchi, for sort of giving us back that zoom out perspective as well, which is quite critical. And I really want to thank all of you for sort of raising the very many layers of the order as well as the challenges that we face today, as well as looking at the positives of it. Because, I mean, I think as Ritwick pointed out, for the first time, one is actually saying that this crisis is affecting the right to life and is affecting the right to equality, and it is recognizing that. And so in that sense, the court has sort of put it out there that this is something that is of grave concern, and hopefully that means that the conversation in public, Kanchi, as you said, also starts taking on a new flavor. And the court has also looked at it beyond it by talking about climate justice, I think, and by also referring to the fact that, migration issues, gender issues, all of these are ways in which people feel the impacts of climate change unequally. And therefore, we have to look at it as a multifaceted problem, not a simplistic one. So I think there are many things that are very positive coming out of this order, but also many things that are open-ended, and possibly future orders will start clarifying how courts are starting to view this issue. And it, I think, also puts the question back in our court in terms of how are we interpreting and expanding the conversation on climate beyond just certain specific sort of much more techno-economic solutions, but actually addressing it as a much wider debate. Because in many ways, both politics and I think in society as large responds to what the societal discourses are. And so I think it is our responsibility to increase the sort of breadth of this discourse in some ways. So thank you for sort of enabling that conversation today. And I realize that there are going to be many more such conversations. So thank you very much. And thank you to the audience.
Thank you for making it happen. So, yeah.
Thank you. Thank you so much.
Thank you.
Bye.